When there's an injustice against you or someone you love or someone you believe in, stand up. Don't sit down on them, if they need you.
Welcome to Popcorn Planet's Pop Culture Justice. I am Andy Signore. Sorry for the late start today, but today's a good one, and we got a special guest. Daniel, the Black Belt Barrister, is here. How you doing, my man?
I'm very good. How are you, Mike?
I'm good. Thank you. It's late over there, so we're going to try and keep his involvement here quickly, but this is an important one. Look, I try not to talk about She Who Shall Not Be Named, but I'm so frustrated by this spin that the media, this clear campaign to try to rewrite history and deny the actual evidence is frustrating to me. And I wanted to bring in Daniel here because he is an actual barrister out in the UK and someone out on Twitter, someone that I tried to ignore, but sometimes it's just hard to ignore when they're out there peddling this nonsense. Miss Kitty Cat 10 Barge is out there trying again to just hit this idea that Johnny gaslit us all. The judge, everybody in the Virginia, we're all crazy. How dare we support Johnny when we should have been supporting the woman? And she puts together this whole thread, breaking it down based off of the UK verdict. Now, Daniel, welcome and thank you. We've talked about this. I know some of the people watching may already have seen us talk about this. But when these hit pieces come out, I think it's important to clip out and have a response ready so people can really understand what's missing. Before I even break down this thread, welcome. Good to see you again, my friend. Thanks for your help on our charity stream last week, too. My God, we raised over $72,000. I'm still blown away.
Fantastic.
So thank you for being a part of that.
Fantastic. Absolutely fantastic.
It was special to have you, and I've been appreciative of you always coming in because, look, I'll admit I'm not the brightest bulb when it comes to law and legal stuff, especially out on your side of the pond. So I appreciate you coming here because I don't like when people like Kat are out there trying to break down this UK verdict as if she understands it better than anybody else and that we're all gaslighting idiots who break it down. Before we even get down and go through this thread to knock it down, I want to start with the most obvious reason why people shouldn't take this UK verdict as seriously. And you've explained to me multiple times, but I want to make sure everybody, the dumbest people in the world who don't understand law, can you break down why the Virginia case was more fair and why the UK case was not? What was it specifically about Amber as a witness that Johnny didn't get to allow to do that I think you can explain to our audience?
Indeed. There's two main reasons for me and for anybody watching that remains confused about this. There are two main reasons for me. First of all, the two different cases, one in the UK, one in the US. The case in the UK was not against her. She was not a party. So to break this down very simply, if one person sues another, they are both parties. One is a claimant or a plaintiff and the other one is a defendant. And anybody else is just a witness, i.e. they come forward to provide evidence that supports one of the parties in the case. They may be independent. They may provide evidence exclusively for one party or another. And in the UK case, that's what she was. She was a witness. She was not a party to the claim. This was obviously between Depp and the news companies. Whereas in the US, she was a party. And that's very important because of a very simple reason that in the US you refer to as discovery, we refer to as disclosure. Some differences between them, but broadly they are the same thing. And so broadly what they are is this. When you come to court, the courts, whether it's in the UK or the US, they expect that court is a last resort, i.e. you've done everything you can beforehand to resolve matters before it comes to court. And the only way you can do that is to provide each other all of the documentation that you rely on or documentation that may hinder your case. So contrary to popular belief, if you've got a document that is a killer email against you that helps the other side, you need to provide it. That's why in discovery, it can be found by your opponent, or in the UK, in disclosure, you must tell the other party, well, there is this email that was written that said X, Y, Z, which doesn't help our case. Now, when you are a party to the claim, i.e. you're bringing the claim or you're defending the claim, you have these rules of disclosure or rules of discovery. And so you must provide all of the documentation required that either supports or hinders your case. Of course, if you're a witness to a claim, those rules don't apply. And that was a section dedicated within what I call the lower court judgment. It's the High Court, but the High Court judgment in the UK. I say lower court because it went to the Court of Appeal, but the High Court's judgment had a whole section dedicated to this because she was not a party and therefore was not subject to those rules. So if you were just a bystander walking down the street, of course, you don't have to show all of the same documents that somebody involved in the claim would. That's the first difference. And so you may then come to the conclusion that it can't possibly be a fair decision when this witness, who's not subject to all of those rules, is essentially the other party, the effective opponent, as Sherborne put it, within this claim. So she was not subject to all those rules. The second reason, of course, is in the UK, it was with a judge, and in the US, it was with a jury. Now, the competing argument, because I'm a lawyer, I'll give you the competing argument so it's fair and you can make up your own decision. But the competing argument is a judge is, of course, trained in the law, less likely to make mistakes, and so on and so forth. However, the clear counter argument is that a jury we entrust in criminal trials because it is so serious that if we're going to punish somebody, we need a jury to make the decision. So you've got a collection of minds working together to assess all of the evidence and come to hopefully a unanimous decision, which of course is what happened in the case, and having heard all the evidence. Now, when you combine those two together in the States, you had not only was she the actual defendant, not just a witness, and therefore subject to all of those rules, the equivalent rules in the United States, but it was also heard by a jury. Now, a lot of people will then go on to make an argument, well, juries can see social media, which I see is part of the thread, that they are swayed by social media. That is not proven to be the case. Invariably, juries will, and jurors, members of a jury will take their role very seriously, and they will not research the case, and they will not be influenced by social media, and they will take it very seriously. And it's usually quite clear when they have done so, and they are then usually discounted and removed, even punished and imprisoned.
Who's to say a judge isn't also doing that, correct? I mean, if anybody could be swayed, a judge, one person could be swayed, even if they're a judge, no?
Absolutely. And there are some famous sayings that with certain judges, that they make their mind up beforehand, and then they write the judgment to fit what they've already decided. And so we're all human. So I think I wouldn't be quick to say that a judge is biased and prejudiced, but I think it would be wrong to say that a judge isn't swayed by some views or something that the judge has seen and read themselves. That is a possibility. And certainly a judge can be criticized. I mean, some people say, well, you shouldn't criticize a judge. You can't say the judge is wrong. Well, if you can't say the judge is wrong, there would never be appeals. And then people will say, obviously, that permission to appeal was refused, but this was on a very narrow circumstance. And so the refusal for permission to appeal in this case in the UK had nothing really to do with the overall case. It was one specific point. So judges can, and certainly are, be wrong at some point.
So because we have some examples to show why Amber was not the most credible witness, and Daniel's
Indeed.
brought some points. We'll go through it, but just to make sure, full disclosure, here's what the media. Kat is a NBC News journalist who claims to not be biased, who claims to say we're all gaslit. Let's hear it out, right? Let's play it. This is part of a great thread about resources to understand why people support AH. I wanted to point out this specifically. It's shocking to me how many people have an opinion but haven't read this. It lays out all the evidence you never heard about on social media. From this thread by Naomi, UK High Court, Andrew Nicole. There's no source like a primary source. If you're wondering exactly what evidence a UK judge spent 3 months analyzing, it is here. This proved Johnny Depp a WB to civil standards. She then proceeds to continue. Each incident of ABUSC, AH alleged in court is detailed in this document alongside supporting evidence or lack thereof, and the judge's reasoning for why he accepts or doesn't accept each claim. This is one of the first primary documents I looked at in my research, and it shows how Depp would lie or forget details at first and then later admit or remember them when faced with evidence, often his own words and text, prior interviews, etc. This is why when people say Amber was all over the place, I'm like, okay, well, did you watch the trial? Depp was the one who couldn't keep his story straight and contradicted himself. This continued in the U.S. trial. Nobody cared. Somehow we're supposed to. So Amber's allowed to do it, but because Johnny did it, he's the liar. Okay, make it make sense. After reading this document early on in the U.S. trial, I realized the full extent of how the public was being gaslit, or in most cases, the public was eager to smear and defame a woman once it was considered popular and permissible to do so in mass. It's often said that victims rarely lie about abuse, and that's the truth, but it's also unheard of to make up 14 incidents of abuse and then corroborate them in court. This is why when I realized she wasn't just telling the truth, she was obviously telling the truth. Well, actually, the
if I could just pause there, Andy, and say
why we're all going crazy about her, because only a psychopath would do that. Daniel, go ahead.
Yeah. If I can just jump in there, when she said it, unheard of that someone makes up 14 is that it's actually not. That's not unheard of at all, because there are lots of cases where if someone's going to make up one incident, they don't just make up one incident. They make up lots of incidents. In fact, we had somebody sent to prison in the UK just recently for a long time for making up several incidents of serious assault, which I won't say to flag up your channel, but a lot of serious accusations that were false, and she went to prison for it. So it is not unheard of for someone to make up these incidents. And in fact, when you go through these incidents, it's not all one-sided. And so when you cherry pick and you snip it out, as Kat has here, with all respect, and snippet and cherry pick the bits that fit the narrative, but without any legal understanding and without any analysis, which on my channel I forget how many videos, lots of videos of at least 20 minutes of length in each, going through each of the areas that I felt were inconsistent, each of the areas that were damaging to credibility, so many so that there was a whole section within this judgment, a headed and subheaded section on credibility. And the section was beginning paragraph 109 for anyone that has the judgment and wants to read it for yourselves. As you got it on screen here, the claimant's challenge to the credibility of particular allegations. And it goes through each of these. And when we move through each of these, I mean, you only need to read the italics subheaders here to get a flavor of what these challenges to credibility are. And if you want to know about them more in detail, I've got 20-minute videos explaining each of these. Alleged lies to the Department of Homeland Security. So there's a whole section here on Savannah McMillan, about what she said in a letter, whether it was even written by her, whether this was a lie, whether or not she was really her assistant and being paid by her, and so on. And that being just one of those credibility issues. And as I say, that this goes
continues,
on.
Right? Then there was the Australian for knowingly making false declaration regarding the importance of her dogs. As we go through, allegation that Miss Heard sought to procure false evidence by Kevin Murphy and Kate James for the purpose of criminal proceedings in Australia. Yeah, I mean, these are all very important things that I think she only read the incidents. She didn't actually read the whole thing. Allegation that Miss Heard tried to grease a vet to procure a necessary travel documentation for the dogs. It's the growth and number and seriousness of the allegations by Miss Heard. This really does speak a lot of towards it. You've pulled a few of these out. this was one you want. Let's go here because I as we go through the thread, she just goes just to show it. She's talking about how the cycle of abuse does this. She's justifying, and everything I read in here, as you can see it here on screen, because I don't want to keep giving it, but I want to make sure you had the opportunity to see it if you want to pause and read what she's writing there. It just screams as someone who clearly is letting her own emotional experience take weight in the reality of it. She's not looking at it objectively. She clearly has her own issues or connecting to her own issues of why she's connected to AH and believes her. And, you know, you're allowed to do what you want. You're allowed to believe who you want, but this is so-called a NBC journalist who's not biased. And it's really frustrating that she gets to say, if you haven't read this, well, you don't know what's going on. Kat, I would implore you, if you haven't spoken to Daniel or an actual barrister, you have no idea what's going on. So do your own homework and do some more actual. And so let's break down this. You wanted me to show this first part because this reiterates the whole point where even the judge admits that she wasn't, go ahead, explain it.
Yeah, so to me, this paragraph 576 for people looking at this, and again, as Andy said, if you want to pause and read it, so it'll make more sense, then please do that. But equally just listen, because a lot of this doesn't make sense. And this, with all respect to Kat, a lot of this doesn't make sense to anybody that's not a lawyer, because it's written in a certain way. It's written by a judge as a judgment to decide the case. But this bit here, for me, is entirely relevant, because this is the judge confirming, admitting, if you like, that she was not a party to the claim, and therefore the rules of disclosure didn't apply to her, and therefore it was unfair. As I'll explain, I think the judge acknowledges here that it was unfair to Depp here, because from the highlighted portion here, because she's not a party, she was not obliged to make disclosure. Disclosure being handing over documents that might go against her. Right, so let's break that down. Because she was not a party, she was not obliged to hand over documents that might make her look bad, is the other way that could be written, right? As a third party, the court can nonetheless order her to hand over documents that might make her look bad, but that essentially didn't happen.
Sorry,
no, that's all right. Down a little bit.
What number was it again? I zoomed
576.
476?
576.
Sorry, apologies. My Zoom
That's okay.
messed it up.
And so
576, he was reading. Go ahead.
There was an application made for this, what we call third-party disclosure. So it's disclosure by someone who is not a party to the claim to hand over these, let's call them documents that might make you look bad. But that application was refused. And so, yeah, we're back on screen here. So the top of this page that's here. Claimant did, so we're reading from the second line halfway along, the claimant, as in Depp, did indeed apply for third-party disclosure. So let's put this into plainer English. So Depp did ask the court to order AH to hand over documents that might make her look bad, but this application was unsuccessful. So the result was she didn't have to hand over documents that might make her look bad. And then the judge goes on to note here, Depp's not been short of legal advice, so I can assume that he would have been advised as to the consequences of suing the defendants in this case, but not her. So it's up to him with that advice if he continues. So what he's essentially saying, without these, let's call them documents that might make her look bad, entered into the claim, it might make it really difficult for him going against the newspapers, but well, that's up to him. And again, spelt out here, the consequences of him doing so are that they, AH, are subject to the obligations of a party to make disclosure.
Are subject to the obligation, yes.
Not AH, yeah. There's no suggestion that the defendants have failed. So newspapers have handed over what, I mean, what would they have? That they report the news based on what they are given. Now, a lot of
and they won the case because they didn't have to prove anything. They're like, well, she said it, and she doesn't have to give you the truth of the full documents. That's how they won it.
Well, they say, the news companies say, well, this is what we were given, so based on what we were given, we printed it. And now the judge is saying, essentially, well, I'm not going to order her to hand over some of these documents. So you're going to have to rely on what the newspapers have got. And in doing so, well, you've taken legal advice. If that goes against you, well, that's down to you. If you bring the claim against them without the information that really could support your case, well, that's down to you. And so for me, that's one of the real key issues here. The fundamental issue in this case.
Yeah, and then we get into the whole issue of the stuff that I don't know why I just lost your places. I had it all organized.
No, sure, that's fine.
And then for some reason when I zoomed, there was a lot of you had me pulled them. I've just lost them for some reason. The thing went away.
Well, what I might do is I've given you a link to this document. You're welcome to share this link. There's nothing secretive on here, so people can see the bits that I've highlighted, and the bits that when I go through it, the bits that stand out to me, I highlight. And just going through the credibility issues alone. The judge seemed to make, with all respect to the learned judge, take great efforts to remove any effect from her and her credibility on this case, more so than I think any other judge that I've come across would have done.
Well, there was a part we had flagged, which was the whole point of basically her trying to grease the veterinarian, to lie about documents. There was one about her trying to basically admitting that they were going to write and try to get her own witnesses, her assistants, to change their stories to save face. All these things keep coming in. There's several examples of it that team Cat keep sort of ignoring, because I don't think they're reading the actual whole document. She wants to come out here and say, if you haven't read all 14 incidents, well, then you can't talk to me. Yeah, but Cat, you got to read the whole report. You got to read the whole report and understand why the credibility is an issue, right?
Exactly. So paragraph 149 you were talking about there.
There it is. Yeah. It's a big document. Sorry, guys. I don't know why I had it all.
Yeah, it's a 130-page judgment. So
can you maybe help Kevin procure a slightly altered health doc that has their shots recorded as 2 days before, so they can all leave together on the 25th? Do we have a vet we could grease? I mean,
yeah. So remember, this is Kate James saying this was an email that she received from and in effect, it's saying, can you give me a falsified health document that shows that these shots were taken earlier than they actually were, so that we can leave on the same day? Do we have someone that we can grease? And for the avoidance of doubt, grease is somehow persuade somebody to give an altered version of the truth. So to lie effectively, for some kind of benefit, will they lie for us? And then connection, so in other words, is there anybody that we have a connection to that we can convince to give a false narrative so that these dogs can come along with us? And so this is, for anyone in any doubt, for me as a barrister reading this, these all must have an effect on credibility. They have to. And there's, as I said, there's a whole section with subsections all talking about these things.
Yeah, it's wild. And so it just blows my mind as people like Cat, the news, are trying to put this out there as if, guys, this is the evidence. You didn't read these specific things that she wrote. But like when I read this, because I did read it, when I read this stuff, it was just very clear that there was no evidence. There really wasn't evidence. There was her word and his. And there were numerous times throughout this when I was reading, the judge just ignored the officer's testimony. I mean, Daniel, did you remember that portion? Like, he was blatantly ignoring certain things that Johnny had put into evidence just because. She was ignoring, she's lied before, but I'm just going to believe her now. There were weird justifications that the judge made in his sort of summary verdict of what it is that made no sense to me. It really, and we've talked about this at length. You've been fighting, but make it make sense, Daniel, please.
Yeah, there's two things there, and one of which is in relation to the police officer's testimony, and the judge even said, I can't remember where the paragraph is, but I remember the wording, said, it's notable that they didn't take a contemporaneous note. In other words, it seems important that the police officer didn't write down exactly what happened in their police notebook, as police usually do. It transpires the reason they didn't do that, which only came out in the US trial, is the whole thing was on video anyway. So If I was walking around filming something on my phone, I wouldn't necessarily think to write it down, because I would think, well, I've got it on my phone. What's the difference? Why would I write it down? And so that came out at trial in the US to show what happened or didn't happen. And secondly, going back to what you said about the weird explanations, and I have to say, again, with respect to the judge, these are what I think are weird explanations. And any other lawyer would think, well, any other lawyer that I've spoken to has said that it's strange, and I'll never name them for having spoken to them. But if you skip along to paragraph 129, this is another allegation where she's alleged to have tried to procure false evidence from Kevin Murphy and Kate James for the same proceedings in Australia. Now, it says here, again, in her words, the only thing we're missing is evidence of the process being initiated, however, not completed. Therefore, the dogs weren't taken on the trip. This obviously harder to prove since it involves documenting something that didn't happen. However, since I know we attempted to bring them at least once before, I can ask her to include that in my statement. And so what she's essentially doing is trying to include something in a statement that didn't happen. But the justification for this was in paragraph, this is the judge's justification, paragraph 134, if you scoot down to where I've highlighted that bit. This is the strange explanation that you're referring to. I had no evidence that Miss James was ever, in the event, actually asked to sign a statement of any kind. In any event, no evidence that she was asked to sign an untruthful statement. So what the explanation here is, this didn't impugn her integrity and her credibility, because although she was trying to get her to give this false narrative, she was never actually asked to sign the thing in the end. But she
merely thought about it, but didn't follow through, I guess is what the
didn't follow through. It's I mean, there's a lot of law about attempted, let's say in a different context, an attempted offense, like an attempted robbery or whatever. The law, at least in the UK, treats them pretty much the same as though you actually went through with it. Because if you made that, the law says that if you've taken steps that are more than preparatory, i.e., if I was sitting here now thinking, you know, tomorrow I might go out and steal somebody's phone, and then tomorrow morning I wake up and think, actually, no, that's a dumb idea, I'm not going to do that. That's not more than preparatory. I've just thought about it. Whereas if I follow somebody around, or I make a plan, or I get an idea of where someone's going to be, and I actually turn up and I'm ready to do the thing, but then I withdraw and think, actually, no, I've changed my mind, I'm not going to go through with it. But then I get arrested. I can get arrested with the attempt of that criminal offense. Now, the courts will treat that as though I've actually gone through with it. At least that's the starting point. It's only a mitigation that I didn't go through with it, but I'd still get prosecuted and convicted of an attempted offense. So that's broadly what we're talking about here, is the excuse as to why this didn't impugn her credibility is that Kate James was not actually asked to sign a statement, let alone a false statement, even though she tried to make that happen.
Well, and it's also important because right there, as you find the whole exchange, Kevin, what do you think? Could you possibly reach out for us? Do you think she'd do it? And then the lawyer writes, I don't know what your relationship is. This time, since you fired her, you have to be careful that she will cooperate and will not go public if you ask her not to be truthful. Literally, the lawyer basically warning her, like, this is illegal. Be careful. Yeah. Well, she stopped, but she was clearly willing until the lawyer told her, you can't do that. So therefore, we have to, she just thought about it and almost did it. Marty, I'm waiting to hear back from you before I reach out to Kevin to liaise with. So it's like, it was all still up in the air, but clearly the lawyers told her not to. But it absolutely speaks to her credibility. And there's a few of these. The Australia one was a big one, but she's it blows my mind. So there's enough here that, again, you've made a big deal at this, as you should. We've even, I know, every time I can to help support this. Wait, I have it here. the Black Belt Baluster. Tell us about this petition, this change.org, and why we're
Yeah,
still trying to make this happen.
So Deb's team applied for permission to appeal, and they had to do so on a narrow point of law because that's the only way you can appeal. It has to be on procedural law. And the one bit of law that they had to make this appeal failed because they said, well, you could have found this the first time round. But even if you did get it the first time round, that one bit wouldn't make any difference, which maybe it would, maybe it wouldn't. But that was the principle upon which the permission was refused. Not, I stress, on the case as a whole. Because I think if the appeal were just to say, hey, let's take a whole look at the whole case again, given the decision in the US, I think it would be very different. But that's not how appeals work. People tend to think an appeal is we think the decision's wrong. Therefore let's hear the whole case again and have a different higher court, like the appeal court, hear the whole case again. But that's not how it works. At least not unless you're in the lower criminal courts where you've got the magistrates versus the Crown Court. So if you're convicted in the very lowest criminal court, which is the magistrates court, you've got an automatic right of appeal to the Crown Court. Then it is a rehearing. They hear the whole case again, but with a proper judge, not just magistrates, with all respect to magistrates. But that's not what happens here. If it's heard in the High Court, an appeal has got to be on a very narrow point because they will not stamp on the judge's judgment. They will not simply say the judge, not automatically anyway, not automatically say the judge is wrong. Although that is one possible point of appeal. It's usually the weakest one to say the judge got it wrong. It's not impossible, but it's usually the weaker point because the appeal court is not quick to say the judge was wrong. It's not to say they never do. But coming back to the point, this petition is to say the court can, of its own motion, say this is really bad. We need to look at this again, on the basis that we now have two completely incompatible judgments, one heard by a jury in which she was the actual defendant, not just a witness, for all the reasons we've said in this video so far, and therefore it should be looked at again to avoid what the rules term in 5230 a real injustice. And you can read that on that petition as to why I say the court should take that decision.
Yeah,
the court
Kat,
can
Amber,
do
they should all want this, don't you think? Because this would put it all to bed. Was it fair? Let's look at, and one other thing I want to add, as you've so eloquently said, though, I just had it. Oh God, why does it keep my favorite part of this also was, hold on, let me hide your comments. I think that was the fact that he specifically talks about that charity money. Here where here it is. I recognize that there were other elements to the divorce settlement, but her donation of the $7 million to charity is hardly the act one would expect of a gold digger. And I remember this being a big deal because he would not bring in the new evidence in that appeal that basically admitted, well, no, she didn't give that money. And that was a one of the many reasons he used to sort of justify his support of AH when in fact she was, again, caught lying. Yet another example of the fact that she's not being credible. So yeah, final thoughts from you, Daniel, as we wrap all this up. Where do we stand on this? Is it frustrating you see this still be spinning? Are you? I know you're still always trying to get it out, but do you think there's still a shot? Because I know Johnny wants to move on, but do you think there's still a shot for us to actually get this reopened?
Yeah, I mean, in all my sense and sensibility, I think that if a court were to look at this situation as it is now, objectively, properly, with all of the evidence that has been heard in the States and the decision that was reached in the States, this should just fall by the wayside. This judgment should not stand any ground anymore. It just, there's too much that has changed. There's too much new evidence that has come forward, and too much has happened for this judgment really to stand credibility moving forward. And it does frustrate me when they are clearly two completely polar opposite decisions, judgments, whatever you want to call them. It's a verdict and a judgment. It's a jury's verdict and it's the judge's judgment. But people will still use this one as to support what they say as their narrative. But just coming and pick up on that point of the the money donated to charity. As we all know, this was cross-examined into the ground by Vasquez, and ultimately everybody could see the truth. And for all we know, the jury found that as the gold nugget, pun intended, to decide this case, because that was demonstrably false. And she knew it. So maybe that was the killer point. We'll never know. There may have been one killer point or half a dozen. But
well, the year is coming up. I think, I guess it's a year after the verdict, so we still have till July or so. But at that point, there was talk of whether these jury members might finally decide to speak up, because I think otherwise they risk causing more trouble. But there's a timeline, and if there's a juror watching, please hit us up. I would love to have that conversation after that year point, but we will see. Maybe they will finally speak up. Maybe they won't. At this point,
I'd love to know.
It does seem like Johnny wants to move on, but as fans of who want justice, if there's a way for us to support, which it sounds like we can, go. Let's get this to 100,000 signatures. Spread it. I'll put the link in the description. It's here in the live chat. Go support it there, because this is something that should happen, and we don't need Johnny to do it. If this can just happen on its own, because they need to reevaluate, because more evidence has finally come forward, and this looks weird, and Justice Nickel is now retired. So let's get this sorted out by someone else and see what happened and clear this up. That would be an amazing win for this to get thrown out.
I can say this would
there
do
would be no
a
more
lot.
argument by these journalists if we could get to the truth.
Absolutely. I can say this would do a lot for the British justice system to have a court look at this again and say, actually, yes, this judgment should be set aside. No more, no less. It doesn't need to order any party to do anything or pay anything. It just needs to set it aside. In other words, it no longer stands. So no, there doesn't need to be an order against anybody to pay anything or to do anything or to take it any further, just to set it aside. And
well done, sir. I appreciate you as always. If you want to get more of this breakdown, you can always go to Black Belt Barrister and get there. I full disclosure, I invited Kat Tedbarge to this conversation once again. She didn't want to come face it. It's frustrating for someone who claims to be a journalist, who wants to hear it all, is doing the research. Why do you keep avoiding it? If you want to do it without me, I'm sure Daniel would be down to talk to you, Kat. So
I'd be happy to chat about it.
Daniel, would you do it? Would you have a conversation with Kat?
Of course, I'd be happy to chat about it.
There you go. Please just do it so you can get educated, because that's really what this is about. Make sure you subscribe to Daniel. I'm trimming this here. More live show is happening, so don't go anywhere if you're watching on the replay. If you're watching on the replay and you didn't catch us live, hit that join button, pick a tier. You'll be able to watch us later, or at least hit that subscribe button, hit that like, and do the same thing over to Black Belt Barrister.